Every day in the USA, people find themselves in court.
Ms. Hagan, can you hear me?
I can hear you. Do you want me to start my video or no?
Did I accidentally include a
Well, you
different,
can wait.
different case?
The cases are both set for a continued. Wait a minute.
And I think that's one of the big issues with what's happening in his case.
Here's Preston Nate. Yeah, Miss Hagan, why don't you turn your stuff on?
Okay.
Are you off school today?
We started spring break today.
Oh, okay.
Well, I guess I included a different case. I'm not sure. I honestly, I should have skimmed through this one a little bit better, it looks like. Yeah, but normally, you know, I mean, you know how I do it,
Mr. Nate,
James.
can you hear me?
I look for the gaps, and then I kind of like trying to remove the gaps and that type of
Yes,
stuff.
Your Honor, I can hear you.
Okay.
Good morning.
Shut up.
Morning.
We have two cases this morning involving LVNV funding versus Jacqueline Lehman, now Hagan.
Yep.
For the first time in about 10 weeks, the air handling system just turned on. It
Do,
sounded like a freight train.
Do y'all actually want to
The file
watch this
number in the
intermediate
LVNV
case, or do you want me to
is
just jump over it?
231204. There's another case, JP Morgan Chase versus Jacqueline Lehman, now Hagan, 231057. We've kicked the can down the road on both of these cases for some time. There are motions for summary disposition set in each case, and they're set for this morning. I had some trouble scheduling this, so we actually moved it ahead. Mr. Nate had an issue and Ms. Hagan had an issue, so we settled on this morning. You've been working for some time and trying to get some resolution here. We started way back in October. Mr. Nate, what's the status here?
Well, it's my understanding, and maybe Ms. Hagan knows a little bit more, but she was or is still working with Clear One Advantage, as my understanding, to kind of get these debts resolved and kind of help her figure out some payment plans that would work for these. From our end of things, we just haven't heard from them. So they haven't reached out to contact us really on either of these files. So nothing's been worked out. So that's why we filed these motions to kind of keep the case moving and maybe wrap it up on the court's end. But that's kind of the status of where we're at, I think. And like I said, Ms. Hagan might know a little bit more about that. But from our understanding, she was working with Clear One Advantage. They just haven't reached out to us yet.
Ms. Hagan, what can you tell us?
Well, I called again yesterday just so I could have like an update, you know, a more recent update for this morning. So there were 9 accounts originally. They settled on 7. 2 have dropped off now. So they said there's a few more accounts that will be paid in full here soon. And then that frees up more money to work with to negotiate the last 2 accounts, from what I understand. They can negotiate sooner if I were to deposit like a large lump sum. Like I have an account where I pay them $700 a month. I think it's $693 exactly. And so that money is what they have to work with to make the payments for the other, you know, for the everything that was in the debt consolidation program. So they were trying to work on like what a total would be, like what I would have to deposit more for them to like settle the last two accounts. There just wasn't any more money left with the monthly payment that I was currently making, is basically where we're at.
Well, we've been delaying things. Neither of those are a defense to the fact that you owe this money. And so we've not entered a judgment. But at this point, my inclination is to grant plaintiff's motion for summary disposition, have these judgments enter, and then you can work with your company to try to make them as part of your debt consolidation program. But I did explain this before, but let me take a minute again. We had a session this week, Mr. Nate, with all the judges. One of the sessions was on dealing with unrepresented defendants in collection cases. And very, very few of them understand the concept of summary disposition. So they filed a lawsuit against you and claimed money damages. Let's go back. This motion for summary disposition doesn't have the dollar amount in it. They filed a lawsuit against you and they served it on you, and you filed an answer. And that started this process where we had a pretrial. In your answer, you didn't deny the debt and you didn't present any legitimate or significant defense to the fact that you owed the money. This is a lot of money. In the JP Morgan case, it's $17,133.05. And in the LVNV funding, that one's smaller, it's $3,942.55. So they filed the lawsuit, you filed the answer, we set it for a pretrial. The summary disposition motion says there is no material issue of fact and the defendant has not stated any defense. It just is what it is. And we ask that you simply enter a judgment on our behalf. They filed it on under MCR 2.116C10. Mr. Nate, I don't have a judgment in the JP Morgan.
Yeah, I apologize. For some reason,
And
I don't think it was.
The motion doesn't have the dollar amount in it. But it's $17,135.95 plus costs.
Well, to clarify, with the JP Morgan account, it would just be the amount paid for in the complaint, the $17,133.95. Chase requests us not to pursue any costs on their files, so it would just be that $17,000 amount.
All right, would grant summary disposition in that case. And ask you to submit an order under the 7-day rule.
Absolutely, thank you.
Now, in the LVNV funding case, let me see if I have an order in there.
And I apologize. You probably don't. If there wasn't one, I apologize. I didn't get in there.
And LVNV funding is under 2.116C9 and C10. And again, the motion doesn't have the dollar amount in it. In that case, the amount is $3,942.55.
Yeah, and this one would include the court costs.
All right, so we have a filing fee of $95, service fee of $59.58. Do they do the statutory attorney fee?
We do not. It would just be the filing fee and the service fee.
All right, so that's 154.58. Equals 4,097.13. Again, I'd ask for an order under the 7-day rule.
I can get that prepared. That's not a problem.
Now, let me explain that also, Ms. Hagan. I made a finding in each case that you had not stated a defense and there was no material issue of fact. And I granted their motion for summary disposition as to each file, which is about $21,000 worth of debt. These are no longer a lawsuit, they are a judgment. And you can present this to your Clear One Advantage representatives and try to make them part of your repayment agreement. But there's no need for a trial here because the standard for summary disposition has been met by the plaintiff. We've adjourned this since October to try to get some resolution and we didn't get there. Under the 7-day rule means he's going to submit the order, 2 separate orders, one for each case. And if they say what we put on the record here, you don't need to do anything. They'll just enter. But let's say he puts the decimal point in the wrong place and it says you owe $170,000 instead of $17,000. Hopefully we would catch a mistake like that. But if you have any objection to the order, you have 7 days to let us know that you object. Otherwise, the orders will enter. But as soon as you get them, I would suggest that you share them with Clear One Advantage.
Okay. So I have to
And
pay
maybe
this.
the reason why they haven't reached out to these companies is because there is no judgment. Now there is a judgment in each file that says you owe this money. You're doing your best to try to not declare bankruptcy. You've had issues. Your husband's had serious medical issues. You're doing the best you can to paddle as hard as you can to keep your head above water. And I do respect that, but you incurred all these debts and you're trying to resolve them one by one. So you're going to get 2 copies of 2 separate orders in the mail within the next few days, and you have 7 days to object. Do you have any questions?
Do I just pay that in one lump sum?
No. No one has $20,000 just sitting around in a pile. They could pursue collection, like garnishment of your wages or your income tax. If you don't have any money, you don't have any money. They aren't going to come, pry the gold fillings out of your mouth, but they have a judgment that says this money is owed. Now, you've been working with this company on at least 7 other debts.
Right.
My advice is you include these with those other debts and try to work out a payment plan. That's what this company is allegedly doing for you. And Mr. Nate, both of these clients are familiar with this company and dealing with it. So it isn't as terrible as it sounds. I mean, you already owed the money. Now I just made a finding that you owed the money. But no, I don't expect you to just write him a check for $20,000. If you have it, great, but I don't expect that you do. At any rate, that's my advice. You share these with your credit management company and they can work with Mr. Mr. Nate's office and see if they can come to some sort of payment agreement. Okay?
Okay.
Do you have any other questions?
No.
All right. I'm glad we were able to do this on a day you didn't have to miss school.
Yeah, no, I
Mr.
appreciate
Thank
it.
you also. All right. We're good to go on both files. Thank you.
Thank you, Your Honor.